here to the 21st seminar of the International PhD in Progress Seminar Series, Phase 3, which is organized by the Global South Network. So first of all, I would like to start the session by thanking Dr. Norman Riyad, lecturer in law, Leicester Law School, who is also the convener and the founder organizer of this entire session and the PhD in Progress series. And on behalf of the Global South Network, first of all, I would like to congratulate on the completion of 60 knowledge activities that this network has organized within 1 year of its establishment, as well as 4 international conferences. And we've had 9 Supreme Court judges coming here from across the world, delivering lectures on topics of importance. Myself, I'm Dr. Ishita Sharma, Assistant Professor from Rajiv Gandhi National University of Law, Punjab in India. And basically my areas of specialization are constitutional law, human rights, and gender justice. And I'm here joined today by Dr. Jing Wong, who is also the discussant for the current session. And she's an associate professor at Leicester Law School, University of Leicester, and she will be the discussant for today's session. And she specializes in antitrust law and competition law, and she teaches postgraduate students in her areas of specialization. Prior to joining the Leicester Law School, she worked at the University of Strathclyde, Scotland, where she researched in competition law, antitrust law, and e-commerce. And I'm also joined by peer commentator Matthew Merchant, who is a juridical candidate from a doctoral student from Columbia and holds a post-graduation in international legal studies from New York University, where he received the Dean's Graduate Award. And he's also worked for the Special Jurisdiction for Peace, the tribunal created in Colombia after the 2016 peace agreement. And in the tribunal, he participated in designing the special restorative sanctions imposed on perpetrators who fully acknowledged responsibility. Moreover, he's trained more than 150 attorneys who represent victims within the procedures of this particular SJP on issues related to rules of operation of this tribunal. And furthermore, in the span of 2020 to 22, he was a professor of constitutional law, legal history, legal research methods, and legal argumentation at Pontificia Universidad Javeriana. Now, last but not the least, the person who is going to enlighten us on the defective development of the basic structure doctrine in Malaysia, Rashida Abdul Hamid, who is a PhD candidate at the Faculty of Law, University of Cambridge. And basically her PhD project, it looks at the role of constitutional identity as a basis for limits on constitutional amendments, specifically in the development of the basic structure doctrine in Malaysia. And apart from this, she's also a managing editor of the Cambridge Law Review and a student fellow at the Faculty of Law, University of Malaya, Malaysia. And her research interests are in constitutional theory, comparative constitutional law, public law, legal pluralism, and the Malaysian legal system. And before undertaking her doctoral research, she was also an in-house legal associate at an investment management firm for 10 years, where she specialized in corporate law and corporate diligence. Now, today, as I already mentioned, she shall be enlightening us on the basic structure doctrine in Malaysia. So, Rashida, you have 30 to 35 minutes for your presentation, and which will be followed by an interactive session. It will be a question and answer session from the side of the discussant, the peer commentators, and the attendees. So now the floor is all yours to continue.
Thank you very much to the chair, Dr. Ishita Sharma, for the very kind introduction. And thank you also to the Global South Network, especially Dr. Riyad, for giving me this opportunity to present my work today. My presentation today is on the defective development of the basic structure doctrine in Malaysia, which was the focus of my first year paper that I presented for oral examination late last year. My presentation is not meant to be a general overview of my PhD project, but rather a specific look at my first year work, which is the diagnostic part of my project. So it will be focusing on the research problem aspect of my PhD project. Next slide. My presentation is going to be divided into two main parts. The first part is the introduction to the research problem. So I will be looking at the relevant features of the Malaysia's constitutional system and the controversial amendment to the constitution passed in 1988. And in particular, I will be looking at the two limbs of the amendment and how Malaysian courts have treated them differently after the adoption of the doctrine. In the second part, I will go into the problems with the BSD in Malaysia, which explain the different judicial treatments of the two limbs of the 1988 amendment. And I will conclude the presentation by a call towards a stronger theoretical anchor for the doctrine in Malaysia. Next. So now I start with the first part of my presentation, the basic structure doctrine and the problem of inconsistency. Next. I start with the constitutional system in Malaysia, and the following are the relevant features in Malaysia's constitutional system. Firstly, it is modeled after this Westminster system of government with a federal structure. So we have one federal government and 13 state governments. And we have a plural legal system, and by that I mean we have a civil legal system which operates at the federal level. And we have the Sharia legal system, which operates at state level. So that means that we have 13 separate Sharia courts operating within their own sphere of jurisdiction. And to complicate matters a bit, we also have a different content of religious freedom depending on whether you are a Muslim or not. Under Article 11 of the Federal Constitution, there is individual religious freedom if you are a non-Muslim, which means that you are free to choose whatever religion you want to adopt. But if you are born to Muslim parents, you are automatically a Muslim in the eyes of the law. And for you to leave the religion of Islam, you require a certificate of conversion issued by the relevant Sharia authority. So if you are a Muslim in Malaysia, you will be subject to the general jurisdiction of the High Court in the civil legal system and the personal and family law jurisdiction of the Sharia Court, which applies only to Muslims. And we also have Article 4 in the Federal Constitution, where the Constitution proclaims itself to be the supreme law of the land. So Parliament is not supreme in Malaysia. But there is no express limit on the powers of Parliament, including the power to amend the Constitution. And this brings us to the backdrop of the adoption of the doctrine in Malaysia, the Constitutional Amendment of 1988. This was passed by Parliament following a clash between the executive and the judiciary in the mid-1980s. And it was passed by virtue of the power to amend the Constitution under Article 159. And the changes were made to Article 121, which addresses the judicial power of the Federation. There are two limbs of the amendment. The first one ostensibly subjects the general jurisdiction of the High Court to federal law, and the second limb ostensibly ousts the High Court's jurisdiction in Sharia matters. Next. So here we see what the amendment did to Article 121. The original text says that the High Court has the judicial power of the Federation. But after the amendment, the Clause 1 was amended so that the High Courts now will have jurisdictions and powers as may be conferred by or under federal law. And a new subclause 1A was created where it says that the High Court shall have no jurisdiction in respect of any matter within the jurisdiction of the Sharia courts. Next. So the two limbs of the amendment represent two different types of threat to judicial power of the High Court. If we use the terminology coined by Yvonne Tew, these two represents first the external threat to judicial power, and the second represents the internal threat to judicial power. The first one coming from Parliament, coming from outside the judiciary, whereas the second one comes from within the judiciary itself, from the Sharia court, which forms part of the unified legal system in Malaysia. The second limb, in particular, has caused a bit of a trouble in cases where Sharia matters in Malaysia have constitutional significance. And the most glaring example is in the cases where it involves the determination of a person's religious status. In the very famous case of Lina Joy in 2000, a woman had applied to leave the religion of Islam, but her application for the conversion certificate was refused by the Sharia authorities. And she brought a judicial review to challenge this refusal before the High Court. But the High Court refused to grant her leave for judicial review and endorsed instead the traditional interpretation of the second limb of endorsement. So therefore, the High Court is said to have lost supervisory jurisdiction over Sharia matters, especially if the Sharia court has heard that dispute. Next. So this brings us to what I call the problem of inconsistency, because in late 2010s, the High Court finally reasserted judicial power by adopting the basic structure doctrine. In the trilogy of cases, Semenya Jaya in 2017, Indira Gandhi in 2018, and Almanudo Atenza in 2019, the federal court upheld that the amended Article 121, Clause 1 did not remove High Court's inherent jurisdiction, and thereby it adopts the pre-1988 position. And this inherent jurisdiction of the High Court was claimed to be forming part of the basic structure of the Constitution. But curiously, the High Court has not gone back to the pre-1988 position when it comes to the interaction between the High Court and Sharia courts. So until today, Lina Joy continued to be good law. And Sharia courts have continued to hear cases with constitutional significance without any supervisory jurisdiction by the High Court. And we have come to a situation where there are different judicial treatments of external threat to judicial power posed by Clause 1 and the internal threat to judicial power posed by Clause 1A. And this is what I call the problem of inconsistency. Next. So that is the primary research question of my PhD project. How did the basic structure doctrine contribute to the problem of inconsistency? My thesis is that the doctrine has been defectively developed in Malaysia. And in order to identify the defects of the doctrine in Malaysia, I look at two things. Firstly, I employ the theoretical method to understand the nature of amendment power and to figure out which type of limits to amendment power that the doctrine of basic structure belongs to. Secondly, I employ the doctrinal method to trace the origin of the doctrine so that I can extract the essential elements. And it is only then that I can make an assessment on whether or not these essential elements have been properly incorporated in Malaysia's application of the doctrine. Next. So now we come to part 2, which is the problems with Malaysian BSD. Next. I have relied on the literature on the unconstitutional constitutional amendment phenomenon to do a general survey on the sources of limits to amendment power. I have come up with 3 basic types of limits to constitutional amendment power. The first one is quite straightforward, which is the explicit textual limit. And I think a very famous example is Article 79, Clause 3 of the German Basic Law. The second type of limit is the implicit textual limit. And I think this has been referred to in the literature as purposive or holistic or harmonious interpretation of the constitutional text. And this method has been widely used in most Westminster-style systems with written constitution, but where there is no express provision to limit the power of parliament. And the third type is a non-textual limit, where the courts have had to rely on unwritten norms outside the text of the Constitution to provide limits for the powers of Parliament. Now, the difference between the second type and the third type can be quite subtle, but I argue in my first year paper that the basic structure doctrine belongs to the third group of limits. Next. It is very important to distinguish between the second type and the third type of limits, because essentially what the court is saying when they employ the second type of limit is that Parliament could not have intended this even if they have the power to do so. So the courts do not go into the process of challenging the power of Parliament in amending the Constitution. Whereas in the third type, Parliament the court fully accepts that Parliament definitely intended this, but the court is saying that Parliament does not have the power to do so. So I think it's quite obvious that the second type can be ineffective in the face of explicitly unlimited amendment power, which is the case in Malaysia. Because simply put, purposive interpretation simply cannot overlook or ignore plain and express intention behind a constitutional amendment. Next. So I compared the rationales used in two landmark Indian cases to illustrate the difference between implicit textual limit and non-textual limit. Golaknath, a case decided in 1967, I argue, employed the second type of limit to strike down an amendment, whereas Kesavananda employed the third type. While both cases involve interpretation of constitutional amendment power under Article 368, I argue that there is a crucial difference. Golaknath's holistic interpretive approach was entirely text-based. Article 368 was read together with another provision in the Constitution, which is Article 13, Clause 2. It was decided in this case that Parliament may have the power to make laws to amend the Constitution, but even these laws are treated or interpreted to be an ordinary law. And being an ordinary law, it is subject to the limits contained under Article 13. Whereas in Kesavananda, the interpretation of Article 368 involved the concept of unamendability that is not textually established. So the courts have looked beyond the text of the Constitution and derive instead extra-textual constitutional norm that requires certain parts of the Constitution to be unamendable. Next. So an essential element of the basic structure doctrine is the shift from text-based rationale, as per Golaknath, to non-text-based rationale, as per Kesavananda. And the Indian courts, to support the doctrine, have used the theories of constituent power and constitutional identity to explain the existence of these unwritten norms. And in doing so, the courts have engaged with India's constitutional history to discover these norms. And this is the crucial stage of the Indian development of the basic structure doctrine. So the written constitution is no longer the sole repository of constitutional norms. And amendment power is inherently limited by these fundamental norms. So according to the Indian formulation of the basic structure doctrine, the original constitutional text is merely an expression of these unwritten norms. And the basic structure of the Constitution is not the original text itself, but the norms that lie behind it. Next. So in order for the basic structure doctrine to be an effective tool to limit amendment power, courts must conceptualize and develop the jurisprudence of the unwritten Constitution. In order to do so, courts must look at the history of the drafting of the Constitution and apply the mischief rule at constitutional level. So the question that the courts must be able to answer is that what was the mischief that the Constitution was meant to address? And the answer to this, of course, would vary from one constitutional system to the next. But I argue that this process is particularly important in Malaysia because we do not have the luxury of a preamble in our constitution. I think in India, the courts have been guided by the constitutional preamble to discover unwritten fundamental norms, but Malaysian courts do not have that luxury. Next. So now we come to the problems with the Malaysian basic structure doctrine. The first problem concerns the way that the doctrine was used in Malaysia, which is as a tool to read down the amendment rather than to strike down the amendment. And we can even ask if it even counts as the basic structure doctrine, because what Malaysian courts have been doing is they have been interpreting Article 121, Clause 1, using a text-based approach that resembles more the Galaknath approach than the Kesavananda approach. The court simply ignored the plain meaning of the language of the amended 121 and imputed to Parliament an intention that, on the face of it, runs contrary to the amendment text. And very crucially, the amendment was not even struck down, and the amended text has remained part of the larger constitutional text. And this allows for the possibility of many different interpretations, which explains the problem of inconsistency. It also sends a mixed signal on the nature of amendment power of Parliament under Article 159. So even years after the adoption of the doctrine, it is still not very clear whether or not there is a limit to Parliament's amendment power. Next. The second problem has to do with Malaysian courts' failure to provide a strong internal integrity to the doctrine. In Malaysia, the doctrine was initially rejected as early as the 1970s. In a very famous 1980 case, which is still very influential to this day, the federal court rejected the doctrine and claimed that due to Malaysia's unique constitutional history, the concept of constituent power does not apply. There is no constituent assembly in Malaysia's independence movement. And the court's rationale was that the constitutional project in Malaysia was not the product of a revolutionary impetus, and therefore the theory of constituent power does not fit very nicely in our constitutional history. And my view is that Pang Chin Hock's rationale was based on a very narrow view of constitution making, and it also involved a misunderstanding on the court's part of the interplay between the basic structure doctrine and the theory of constituent power. But despite this, it is, to me, a missed opportunity for the courts when they failed to address this rationale, because it could have given the courts an opportunity to strengthen the basic structure doctrine and to give a more sound theoretical foundation to the doctrine. Next. And the third problem with Malaysian basic structure doctrine to me is the primary problem. And that is that the Malaysian courts have failed to conceptualize the unwritten constitution of Malaysia. It has failed to provide the answer to the question of what lies behind the text. The courts in the trilogy of cases through which the doctrine was adopted, the courts did not make any reference to higher norms that led to the creation of the constitution. So even as they said that Parliament did not remove the inherent jurisdiction of the High Court with the introduction of the amended Article 1211, the court was saying that Parliament's amendment power is somehow limited, but it does not say what is the source of this limit on Parliament's amendment power. So this leads me to the conclusion that what the doctrine lacks in Malaysia is a sound theoretical framework within which the doctrine can operate. The construction of a theoretical framework for the doctrine requires a more active engagement with Malaysia's constitutional history, which Malaysian courts have tried to avoid so far. Next. So this brings me to the conclusion of the first part of my project. Next. Which is that the problem with the basic structure doctrine in Malaysia is not just in the way that it is used by the courts, which is to read down the 1988 amendment rather than to strike down, but primarily in the failure to conceptualize the constitution beyond its written form. Unwritten norms must come from somewhere, and there must be a rigorous account of the unwritten constitution of Malaysia to explain where these norms come from. And we see that in India, the Supreme Court had relied on the theories of constituent power and constitutional identity as possible sources of fundamental norms. And I think these theories fit well with India's constitutional history. But the question is, do they fit well with Malaysia's constitutional history? And this raises the questions that were first raised in the 1980 case of Pang Ching Hock. Next. And that is what I'm looking at currently in the next part of my PhD project. I look at several different theories in order to find the best theoretical anchor for the Malaysian basic structure doctrine. This theoretical anchor must sufficiently explain specific features of Malaysia's constitutional arrangement. And I have shortlisted three theories. The first one being the theory of constituent power, because mainly because it was already formed part of the Malaysian literature on the basic structure doctrine. So the second one is the rule of recognition, and we can find evidence for the operation of the rule of recognition in the court's upholding of the pre-1988 position for Clause 1 of Article 121, despite the amended wording still being part of the text. So what we see here is that the judges have come to a consensus to simply ignore the amended wording and uphold instead a version of judicial power that they believe is what animates the Article 121. And the third potential theoretical anchor is the theory of constitutional identity, which I primarily draw from the works of Professor Gary Jacobson. So this is the next part of my PhD project, where I critically analyze the suitability of these theories and whether they fit well within the Malaysian context, and if they can provide sufficient theoretical grounding for the doctrine in Malaysia. So we've come to the end of my presentation. Thank you very much.
So thank you, Rashida, for your presentation, and you gave a very brilliant analysis of the basic structure doctrine and fitting it within the contours of Malaysia's constitutional governance. So now I would want to welcome Dr. Wong, where as a discussant, she gives certain enlightening comments on Rashida's presentation.
Thank you, Chair, and thank you so much for the amazing presentation. Definitely, this is not my area, but I'm learning a lot. So my question is really about discussion to actually answer some of my curiosities about your research.
Okay.
First of all, I would like you to just tell us very briefly why your research is very important. and you actually selected several cases in your research. Would you like to tell us more about why you actually selected those cases? Is there a common theme in between them? And also, you identified 3 angles for your next step. I'm just wondering, is there any links between the cases you selected within those 3 angles you actually identified? Meaning, what actually linked you from your current chapter to the next? And you also mentioned in your abstract that this research is about a comparative study, mainly on Malaysia, but also compared to India. So I'm just wondering, because there are cultural and religion differences between both two countries, so I'm just wondering how much those differences actually affect your research and how much those differences being considered in your research.
Yes.
Yeah. And the last one, I think my question, my just again, this is really my curiosity. So do you think there is any extra value bring to you when you conduct this research in the UK?
In the UK, okay. Okay, I think I can pair the first and the last question as to why my research is important. My research, I think, is primarily important because I think the problem of inconsistency, which I raised in the first part of my presentation, is a problem that hasn't been solved. Because on the one hand, we say that judicial power of the High Court is inherent, but at the same time, we are also asked to accept that this original jurisdiction doesn't exist when it comes to Sharia matters. And there is no consistency as to the idea of judicial power in Malaysia. And I think without addressing this problem of inconsistency, the nature of judicial power in Malaysia will remain vague and very ambiguous. And whether there is a value in the UK, I think that as the UK, the constitutional discourse in the UK has also moved beyond what I think the traditional understanding of parliamentary supremacy in the UK. And I think scholars here are also moving towards the discourse of norms of the constitution that actually can provide limits to the power of parliament, other than the orthodox understanding of parliament in the UK. So I think perhaps that can provide, my research can provide value in that sense. I think the second and third questions can also be linked, because you were asking about how I selected the cases, and the common theme of the cases in the doctrinal part of my research is that I look at cases where the courts have relied on the basic structure doctrine in order to strike down statutes in Malaysia, because I have had to select these cases because in Malaysia there have not been any instances where a constitutional amendment itself was struck down. So I have had to modify my selection criteria to include cases where the doctrine was claimed to be the reason why a statute was struck down. And whether there is a link between the cases and the 3 potential theories that I'm looking at currently, yes, the link is that these theories can explain why the doctrine comes to the rescue for the courts to impose limits on parliamentary powers. So for constituent power, for example, the court has actually explicitly engaged with the theory of constituent power, but the outcome that was reached led to the rejection of the doctrine previously. So now I think it is a pertinent theory to engage with, considering that the courts have never addressed that criticism raised in Punchin Hock. As for the rule of recognition, I think I see evidence in the way that the courts have reached a consensus as to which idea of judicial power it wants to endorse. And in the rule of recognition account of the unwritten constitution, my preliminary argument is that it is not actually the written constitution that provides the criteria of validity in the Malaysian legal system, but what judges among themselves have agreed to endorse and to accept as what forms the criteria of validity. And finally, the comparative angle of my study. And as you have rightly pointed out, there are crucial differences between India's cultural and religious, I suppose, landscapes. And I think it is the differences that the Malaysian courts have failed to be mindful of in their importation of the doctrine from India to Malaysia. And I agree with some comparative scholars where they say that sometimes the differences are more important to emphasize than the similarities. And it is actually quite crucial in my study that the differences are underscored, because the Malaysian constitution is modeled after the Indian constitution. And I think the things that are missing from the Malaysian constitution can say a lot, because the decision to remove certain parts of the Indian constitution from the Malaysian model can say something about what the predetermined fundamental norms are. So why did the drafters of the constitution choose to leave out certain things? And I think in copying another constitution, it is easier for you to just leave the original version as is. But if the drafter chose to leave out certain things, I think there is a conscious decision to remove those features of the Constitution. And I think the differences are what's more instructive in my study than the similarities.
Thank you. Thank you so much. I think I still have other questions to ask, but I think it's just a concern about time. We should invite the peer counters. Here.
But thank you for the questions.
Thank you so much.
So that was a quite a good parlay of question and answers. Now I would invite the peer commentator, Matthew, if he has any questions for Rashida.
Hi, thank you. Hi, Rashida. Congratulations. Hello. It's a great research and very interesting, and I think that's it's a very important topic for the global discussion now, because the basic structure doctrine and the constitutional amendment doctrine, it's part of the discussion on comparative constitutional law in many different jurisdictions. My question has to do with the context of the discussion, because you present at the end of the presentation these theories that may explain the kind of inconsistencies of the using of the basic structure doctrine by the Malaysian court. But I was wondering, and I will say this because I just read a paper by let me look for the name, Nicola Tomasini. He does a kind of comparison between the Malaysia basic structure doctrine, the Colombian constitutional doctrine, and the Indian doctrine as well. focusing on the judicial self-empowerment of the Supreme Courts, of constitutional courts of those jurisdictions, using the doctrine as a means to entrench the judiciary, right? So, and he explains the kind of political context within which the Malaysian court unfolded the basic structure doctrine. And I was wondering if there is a place for those kind of considerations in your research, because I understood that it's a kind of very like legal analysis, because you are looking at the theories kind of showing up the using of the doctrine, but maybe it's important to see if with a given decision the court was a kind of acting in response to a specific political problem. Maybe that's something interesting that may explain the inconsistency of the doctrine in the Malaysian case. So that was my question.
Okay. Yes, I agree with you that there was, of course, the political context that informed how the courts approach constitutional amendment of 1988. And I think the political context was very important because the amendment came in amidst the political situation where the Mahathir administration, the executive, and obviously because it's a Westminster model, the parliament as well, were in direct confrontation with the courts. So the constitutional amendment of 1988 came as a result of a parliament versus judiciary conflict. And but I think many scholars have forgotten the second limb of the amendment because of the origin of the amendment as a parliament versus judiciary conflict. The second type of conflict, which is the civil court versus Sharia court conflict, has been pretty much ignored and has not enjoyed the same level of scholarly attention. And you're right in saying that the political context has been can have influence over how the judiciary approaches the amendment. And I have addressed this in my first year work by saying that because of this parliament versus judiciary lens that the High Court was using in approaching the amendment, it has led to the doctrine being used as a tool in parliament versus judiciary conflict, but not in Sharia court versus civil court conflict. But I do plan to come back to this political conflict, political context of the amendment in my discussion of the theory of constitutional identity, because I think the constitutional identity theory can provide a good basis to as a theoretical anchor for the doctrine, because it will force the court to come to terms with specific features of Malaysia's constitutional system that are not present in the Indian system. For example, the plural legal system, the differing contents of constitutional rights depending on the religious status of the individual, and so on and so forth.
So I would like to ask if any of the attendees over here have any question for Rashida. If anyone wants to ask any question.
I have a question and comments and a lot to share, but I just want to check, that if any of attendees have any question, don't want to abuse my position and the role. All right, so okay, the first, it was, I'm short of words to appreciate the presentation. I think it's one of the most important topic, basic structure doctrine, and its general importance is, if I give a very simple example, the daily life example, it is like asking you not to grow because you have certain features that can never be changed, and you're not going to change that thing, and you're not supposed to grow that thing. Now I'll give you example. I think it's everywhere. It's written, it's unwritten, but it's everywhere. And I will start with the Chinese constitution, the first chapter, general principles, article 1, Minzuan, Mincheng, Minquan, nationalism, democracy, livelihood of people. And whole constitution is based on these three principles, and everything is centered around that. And in every court, jurisprudence, because it's written in they deliver in the Chinese language, it's very difficult to interpret and then analyze that thing, except the Chinese scholars. Very few books are available, but that does echo something very similar to the basic structure doctrine, which in short means that there are certain features that can never be changed. Now, when it comes to the written basic structure doctrine, the only constitution in this world that explicitly says that these are the list of features that can never be changed is the Bangladeshi constitution. Article 7 of Bangladesh constitution provides that thing. And I think why it is important is that it, on the one side, undermines people power, parliamentary sovereignty, and undermines the principle of separation of power. That is one way of looking at that. On the other side, it also appreciates, recognizes the majority will. For example, and I think that when it comes to the majority will and the discussion of counter-majoritarian problem and the majority's will, your discussion of constitutional identity comes into play. And that actually explains why basic structural doctrine is the principles and the features are, they vary from one country to another. For example, in case of India, one of the feature is secular state. So you cannot declare that India is a Hindu state. So that parliament cannot do that thing. But on the opposite side, flip side, take a flight, go to Pakistan, 18th Constitutional Amendment. The parliament cannot say that from now onward, the constitution is secular. It has to be Islamic. So Islamic law is the supreme law. That parliament can never do. One of the features. And the second is the federal court. And the third is the judicial independence, which is, by the way, very similar to the list of features provided in the Indian jurisprudence. Same goes for there was a talk about the United Kingdom. Now, when it comes to United Kingdom does not use the word basic structure doctrine, but through the case law, it does capture the importance of the similar principles. For example, judicial independence, rule of law. There's no question about that. That is off the table. So you can never say that there is no judicial independence. Let's control judicial independence, or there will be no rule of law. That is off the table, and that is de facto. In practice, it is something very basic. And you are absolutely right that after devolution and the series of constitutional reforms in late 1990s and early 2000s in the UK, the system went more towards semi-federal, in terms of devolution. It changed towards that, and a lot of power has been given to that, the Supreme Court and the higher judiciary. Now, my only question is about when you mention the constitutional. So one question is about the constitutional identity. And when you say constitutional identity, did you consider looking at the composition of the Malaysian judiciary? Because when it comes to Malaysian judiciary, so we have three kinds of, there are three groups of judges. That's how I look at the Malaysian higher judiciary. Correct me if I'm looking at it incorrectly. So Malaya, Sabah, Sarawak, 3 ethnicities are there. So did you consider, and most of the time, I tell you something, I can give you the example of Ran Harshe, the unconstitutional constitutional amendment, when you talk about that, Aaron Barak, Yanni Froznai, they did mention this thing, that how the social background, so ethnic national background affects your judicial interpretation, approaches to judicial interpretation. And in these kind of compositions, like federal judiciaries, it is important to see, how many judges from which background, what kind of approach they take. And if they didn't say anything, neither strike down nor uphold certain principles, it's also possible that they did it on purpose, just to assert that we do have power to look into this thing, but for now we do not want to determine because of the division within the court. Sometimes it's also possible, and I just wonder, did you think about that? That is because of the division within the Supreme Court judges and the way they look at that principles, it's possible that they didn't reach the decision and they didn't want to make it public. Most of the time it happens, it's a convention within the judges community, that a lot happens within closed doors when they write judgment, but they don't want to make it public. But from the judgment writing, the tone and the tenor and the flow of discussion, you can clearly see where are the disagreements and how that disagreements can be connected to the judge's ethnic background. So I just wonder if you consider, when you were analyzing the connection between constitutional identity and the basic structure doctrine.
It's actually quite interesting that you mentioned the composition of judges that form the judicial benches in Malaysia. And you're quite right to point out that there's a High Court of Malaya and the High Court of Sabah and Sarawak. And for those of you who don't know, Sabah and Sarawak are the Borneo states that form part of the Federation of Malaysia, whereas Malaya is the peninsular comprising 11 state governments. It was actually something that I was interested to look at, the more, I suppose, sociological aspect of the phenomenon of the basic structure doctrine. But I think that for now, my direction is more on the constitutional and the legal aspect of the doctrine. So I look at the rationale provided by the judges rather than their own personal leanings, because I think I just do not have the resources to go into that aspect of the doctrine for now. But that is certainly something that I agree can have a bearing and influence on how certain judges approach the question of the basic structure. Because even now, there is, I think, the issue of the racial and religious status in the constitution remains a highly contentious issue in Malaysia. And to say that judges have reached a consensus over the status of the Malay rights in Malaysia, for example, would be an overstatement. Sometimes you go to the High Court, and the High Court would return a judgment endorsing the fundamentality of Malay rights and the status of Islam in Malaysia. But then the next year you go back to the same High Court and you will have a different finding or different endorsement. And obviously, I think that is also quite pertinent in the discussion of constitutional identity in Malaysia, because currently my preliminary finding in my analysis of the theory of constituent power is that it can be ultimately self-defeating, because it's quite clear to me that what Malaysian courts are doing by adopting the basic structure doctrine is to preserve certain constitutional principles. And by doing so, they are forwarding a set of normative claims about what a constitution ought to do and what a constitution ought not to allow. So, and I'm very aware of the Schmittian dangers of the theory of constituent power. And if Malaysian courts rely only on constituent power as the theoretical anchor for the doctrine, it can prove to be ultimately self-defeating. So rather than confine the operation of the basic structure doctrine, it might allow the majoritarian instincts of the Malay and right-wing Islamic community in Malaysia to be constitutionally entrenched. Yes. But thank you for the observation. I think that can be an interesting area for me to look at after my PhD project is finished, hopefully.
Thank you very much. Just to add, one small comment. There's a BBI case decided by the Kenyan Supreme Court last year. I think that would be very useful because around 13 scholars from across the world that they appeared as amicus in that case before the Supreme Court, and it's like 1,000 pages. So it's all about basic structure doctrine, and it's currently every book on the basic structure doctrine does not miss that thing. So you probably may wish to look at that, and might add to your literature review.
All right, thank you very much.
So basically, I have one final question, Rashida, as basic structure doctrine. So basically, as far as the basic structure doctrine is concerned, in India, it came in the backdrop of social justice. Basically, it was all focused around, the debate was around right to property under the Indian Constitution. And in the Golaknath case, basically the Supreme Court said that fundamental rights have a primacy. And it was a kind of a tussle between fundamental rights and the directive principles of state policy, which are there in the Indian Constitution. And basically this doctrine has historical as well as philosophical underpinnings in India. Like the government was on a drive for the redistribution of land, but it was infringing the right to property of the citizens of the country. And it was in this particular backdrop that the basic structure doctrine primarily came up in the Keshwan and Bharti case, because in the Golaknath case, it was said that fundamental rights are supreme and the parliament, cannot cannot abrogate the fundamental rights of the people. So in that backdrop, we had the 24th Constitutional Amendment Act of 1971, which said that an amendment is not a law. An amendment is not considered as a law, so it's outside the purview of judicial review. So basically, it was a tussle between social justice and individual rights under the Indian Constitution. So as I could gather from your analysis, you've basically highlighted on the political situation in Malaysia in the backdrop of which the basic structure doctrine came. So I want to know what are the philosophical underpinnings of this particular doctrine in Malaysia, how they've adopted this particular doctrine. Like in India, the prime focus, the epicenter of this doctrine is right to property under the Indian Constitution, vis-a-vis the payment of compensation to the person whose property is being taken away for public interest. And here in India, the public interest was the redistribution of land, because in the colonial times, the zamindars, they dominated and the sharecroppers had no share in the compensation of the land that they were tilling on. So it was in this backdrop that the basic structure doctrine evolved in the Keshwan and Bharti case finally. And there were a many slew of amendments like the 9th schedule of the Constitution, 24th Constitution. So this was basically the philosophical foundation of this doctrine. So I want to know whether in Malaysia, what is the philosophical foundation of this doctrine in Malaysia? Like here, social justice and individual liberty are at interest are at loggerheads with each other. So what is it in Malaysia apart from the political angle that you're focusing on? What is the philosophical basis of this entire doctrine in Malaysia?
If I have to pin down just one philosophical underpinning, I think it would be the notion of judicial power in Malaysia. Because the 1988 amendment was widely seen as an attempt by Parliament to curb judicial power, because what happened in the 1980s was, I think there was a resurgence of judicial activism in the 1980s, where there was a string of judicial decisions where the executive decisions of the administration were quashed. And I think it culminated in one landmark case where the federal court incorporated the principle of legitimate expectation in Malaysia. And in that case, a foreign journalist whose work visa was already issued, had his visa revoked by the government of Malaysia. And the federal court quashed that revocation and said that, you know, the journalist had a legitimate expectation for the visa period to go on without interruption. And it was in this context that the amendment was introduced. What the administration was doing was trying to get the courts away from how they wanted to, the kind of changes that Mahathir wanted to introduce in Malaysia. So it was quite a straightforward tug of power between Parliament and the judiciary. But Mahathir also used the constitutional amendment to reinsert, or basically to strengthen the position of Sharia courts in Malaysia, because this is an ongoing conflict in Malaysia where the Malay and the Islamic community are very worried about the issue of conversions, where Muslims should or should not be allowed to leave the religion of Islam. And politically, the amendment was supposed to kill two birds with one stone. But the primary underpinning of the amendment was the issue of judicial power of the High Court, whether the High Court can strike down statutes passed by Parliament, and whether the High Court can say to the Sharia courts that, no, you do not have exclusive jurisdiction over the content of an individual's religious freedom. So I would say that that is the philosophical foundation of the basic structure doctrine in Malaysia, the question of judicial power of the High Court.
So thank you, Rashida. It was a very insightful presentation. Basically, your presentation highlighted how interpretation varies according to the social context, the social backdrop, how the same structure, so same basic doctrine structure, starting from South Africa, traveling across continents, has assumed varied meanings based on the social parameters of the particular society or the country in which it is brewing. So it was a very insightful presentation. Once again, I would like to ask if anyone has any queries or has any sort of comments or any sort of observations on Rashida's presentation. The house is open. Anyone? Again, I would like to ask anyone. So you're safe, Rashida. Now you have no more questions. You had a many string of questions that flew, and you successfully tackled all of them also. And it was a very insightful presentation. So I would like to thank each and everyone present over here, and primarily Rashida, Dr. Norman, Dr. Wong, and Matteo, who provided his insights on Rashida's presentation. And next week at the same time, Mohammed Dervis, who is a candidate, a doctoral candidate from University of Edinburgh School of Law, shall be delivering his PhD presentation on judicial dilemmas, unraveling the paradox of high courts in the age of populist threats to democracy, insights from the Turkish experience. So basically, we've come to the end of this insightful presentation. Thank you, Rashida, and thank you everyone over here for attending the same.
Thank you, everyone.
Thank you. Thank you, everyone.
Have a great day.
Thank you.
Thank
Bye-bye.
you. Bye.